How to file small claims in Harris County. In this video we will cover: what is a small claims court jurisdiction in Texas? Who can sue small claims case in Harris County? Who can be sued in a small claims case in Harris County? Which court to use for small claims filing? When can I file a small claims case? How to file small claims in justice courts? What is the fee structure for small claims in Harris Justice Court? We will explain step-by-step process. This video is created by smallclaimstexas.com. If you are not able to do all the work by yourself, smallclaimstexas.com can help you to file your small claims in Texas and prepare your documents. What is a small claims court jurisdiction in Texas? The Small Claims Court in Texas is created under Chapter 28 of the Texas Government Code. It has concurrent jurisdiction with the Justice Court in actions by any person for the recovery of money in which the amount involved, exclusive of costs, does not exceed $20,000. Who can sue small claims in Harris County? Any person over the age of 18 years can sue in small claims court. The party filing the suit is the plaintiff. A minor can use the court if accompanied by a parent, relative, or next friend over the age of 18 to file a claim and later go with the minor to the trial. An association, partnership, or corporation may also file a claim in small claims court. However, a partnership, association, corporation, or person engaged in the business of lending money at interest or functioning as a collection agency may not file a claim in this court. Who can be sued in a small claims case in Harris County? Any natural person, association, partnership, or corporation over which the court has jurisdiction may be sued. The person or business being sued is called the defendant. The court only has the power to enter judgment against a defendant if that defendant is present in the state of Texas or makes its permanent home in the state. In the case of a business, if it is a sole proprietorship, the individual must be present in the state, or if it is a corporation, the corporation must be doing business within the state. Which court to use for small claims filing? The justices of the peace in each county sit as judges of the small claims courts. The addresses and telephone numbers of these courts are in the city telephone directory. If there is more than one justice of the peace court in a county, then a small claim normally must be made in the court of the precinct which covers the area where the defendant lives. Under some circumstances, the plaintiff may have a choice of courts in which to bring a claim. For example, if the defendant lives in one precinct but does business or contracted to perform services in another precinct, either precinct can be selected as the place to bring suit. When can I file a small claims case? For the court to be able to act on a suit, the suit must be filed within time limits set by the legislature. A court has no power to hear a suit that is filed after these set time periods. Many suits must be brought within 2 years after the dispute arose, others must be brought within 4 years. To be safe, you should file suit as soon as you are convinced you cannot recover the money on your own, and before 2 years have gone by. How to file small claims in justice court? In order to begin formal action, the plaintiff must personally go to the civil clerk of the correct justice of the peace court and do the following. Fill small claim statement form. Ask the clerk for a small claim statement form, and be prepared to provide the following information to complete the form. The plaintiff's complete name and address. The defendant's complete name and address of each person or business the plaintiff's claim is against. Correct names and addresses are vital to the plaintiff's case because the court cannot grant a judgment against a defendant who is improperly named in the petition. Therefore, plaintiff must determine the correct legal name and address of the person or business being sued before going to the clerk. If the business is a partnership, the partnership should be named by its correct legal name and all partners should be named individually. The amount of the plaintiff's claim. The basis of the plaintiff's claim stated plainly and without technicalities, including the date the claim arose. The amount of money the plaintiff properly owes the defendant, if any. Swear under oath that this small claim statement is true. To begin an action in the small claims court, the plaintiff, or claimant, must make a statement of the claim under oath. This may be done by the plaintiff, by the attorney for the plaintiff, or by an authorized agent for the plaintiff, in one of two ways. 1. By appearing in person before the justice of the peace or the clerk and filing a statement of the claim under oath, or 2. By filing a sworn small claims petition with the justice of the peace or clerk of the court. Pay the clerk a filing fee. The justice of the peace must collect total fees of $34 for the filing of a claim in the small claims court. It includes the filing fee, the service of citation fee, to cover costs of serving citation on the defendant. Service of citation. In order for the small claims court to acquire jurisdiction over the person being sued, the defendant must be notified of the filing of the lawsuit. When the claim has been filed and the filing fee paid, the justice of the peace or the clerk will issue a notice of the filing called a citation. The citation is served by an officer of the state authorized to serve other citations and may be served in any manner authorized for service of citation in a justice court. Citations may be served by personal delivery to the defendant, or by registered or certified mail directed to the defendant, with a return receipt requested. No judgment may be rendered against a defendant unless the defendant has been properly served with the process server. Appear in the court. On the date and at the time scheduled for the hearing, the plaintiff must appear ready to present proof of the amount he or she is claiming is owed by the defendant. The defendant must appear ready to present proof of any defenses he or she may have to the plaintiff's claim. Each party may offer written records, photographs, other tangible evidence, or the testimony of witnesses who have personal knowledge of the transaction made the basis of the lawsuit. A concise presentation, without repetitive testimony, is the best way to present the case. The justice of the peace may allow each party to make a short argument on why that party should prevail. The hearing is informal and the justice of the peace may ask questions to develop the facts of the case. At the conclusion of the hearing, the justice of the peace must make the judgment as the justice of the case demands. You may hire the professional staff of smallclaimstexas.com to prepare the right forms for the right court. The link is in the description. Thank you so much.